Okay, we are going to start the webinar. Good morning, everyone, and I welcome you to my first webinar on compliance of SEBI Investment Advisors Regulations 2013. I request you all to please mute your mics. So, before we start the webinar, I want to introduce myself. As you all know, I'm CS Kruti Bogri. I'm a practicing company secretary. My core area of practice is SEBI regulations, and I am currently operating from Mumbai. And this webinar I am conducting to help you all do compliance of SEBI regulations. Okay, so before we start, we should know why we all are here. The points which you see on the screen are the agenda for today, but of course, we all know that we are here to understand the compliances which are applicable to different type of businesses under SEBI Investment Advisors regulation. But doing compliance is not just one thing; it has many parts to it. There is record keeping, there are internal processes which you all need to take care of. Okay, so I'll take you to these parts one by one. We'll have different topics discussed. And, this is my best effort to help you bridge the gap between where you are currently and where you should be in terms of compliance. So that SEBI doesn't come knocking on your doors. So as you can see on the screen, we are first we'll discuss why IE regulations came into existence. This is very important because you should also know, the spirit of SEBI regulations and what is SEBI intending to do through IE regulations. Then we will see what is a typical RI practice. I will take you through a case study which is practically happened, and SEBI had issued an order against a company who was registered as an investment advisor. Then I will also cover the most important part, that is compliance of IR regulations. That will lead us to how you should be prepared for annual audit, which is mandatory to be carried on by all registered investment advisors. I have been getting a lot of questions on what could be the cost of compliance. This is basically for someone who is starting to get into this practice. And of course, last session we'll have for questions and answers. In between, if you have any questions, you can write to me. I'll try and take it in between, and if cannot, I'll definitely try and do it after the end of presentation. So you all know that in the past, IE regulations have been in news, especially because SEBI issued 3 consultation papers for amendments or changes which are proposed in the IE regulations. And of course, recently IE regulations was in news because the Finance Act gave more powers to SEBI to levy penalties. Okay, so before I take on to the compliance part, we will first know why IE regulations came into existence. So basically, SEBI wanted to tackle a conflict of interest in distributing financial products. The distributors who were earlier acting as investment advisors, they had a conflict of interest as they played a dual role. One, from the AMC side, where they were getting brokerages, and the second, for the investors to whom they were advising the products. So there definitely, SEBI thought that there could be a conflict of interest as they are getting fees from the clients as well as commissions from the AMCs. And to tackle this conflict of interest, SEBI thought that they should come out with IR regulations. Of course, you all know that IR regulations is a legal framework governing the working of investment advisors. And the last is code of conduct. So I don't know how many of you have really read or gone through the code of conduct, which is at the last of the IA regulations. That's a schedule to the IA regulations. If you go through the code of conduct, you will know that this is again a governing or guiding points for working of IA regulations. And in between, wherever references are there, I will take you to the code of conduct as well. So before we go ahead, I also want to touch upon what is investment advice. This is mainly because you should know what all you are doing and what does come under IA regulations. And the basis is how do you judge that it is an investment advice. So basically, any advice which you give to a client on his or her securities or investment portfolio is an investment advice. Of course, it has to be communicated. Either it can be oral or in writing, and it has to be in the benefit of, for the benefit of the client. It has to be in the interest of the client. And very broadly, it also includes financial planning. So you can be giving advice on a particular stock or mutual fund, or you can be doing a full-fledged financial plan for the client. So the next is what is a typical RIA practice. If you see on the slide, I have given steps on how does the client, when does the client onboard and how do you deliver the advice. And I believe that this is a typical practice which almost all investment advisors follow. So this is a process of delivery. For you, your lead either comes through a website or through a referral, or you must have advertised your services somewhere and the person comes to know that you are providing investment advisory services. And of course, the person is looking out for some advice on his financial situation. So a lead comes to you for financial advice. After that, the lead tells you on his requirements and what is he looking for. You talk to the person, meet the person, understand what kind of services he or she requires, and of course, you explain him or her the features of your services. He may have seen something on your website, depending on which he may have decided to at least get in touch with you. After you explain the features of your service and the terms of your service, the lead agrees to take your services. Once the lead agrees, it becomes your client and you collect all the financial information about the client. You take his basic financial data and of course the purpose of why he is going to invest in a particular in a stock market or a particular financial product. Several interactions happen between you and the client via phone or email. After interactions happen, you discuss with the client, you deliver the financial advice or the investment advice to the client. The client is happy with the advice and agrees to it and then moves forward to the execution part. Is this what you all are doing? Do you think this is the perfect process? Is anything missing in this? Do you think this process is compliant of IA regulation requirements? I'm sure you all must be thinking it is because it looks like a typical RIA practice, but before we go ahead and see whether it is or it is not, let's see what a registered RIA did when it was following the same process. And I'm now referring to the company Capital Via. Okay, so I'll give you a brief background on this company. This company also was following almost similar process which we discussed in our last slide. Okay, this case happened in 2016. This company was into intraday trading and all its products were designed on the basis of intraday trading, and of course the clientele also consists of people who want to carry out intraday trading. This company was charging fees of as high as 25 lakhs per client, and also promising or assuring returns of 10%. Some client who obviously was not happy with the company and its services complained to SEBI about the company. SEBI conducted an inspection of books of accounts, records and documents of the company. The company had the office at Indore, and SEBI went and did a personal inspection of the books. And after the inspection, SEBI came to know about various non-compliance, various areas where capital via failed to comply with. So I'll just brief you on the various areas which you all must be aware, which are included in our investment advisors regulation. The company was not taking KYC documents of the client. So the company was taking KYC documents, but it did not take KYC documents for all the clients. It did not follow the KYC procedures that were laid down by SEBI from time to time. The other non-compliance was it was giving advice before doing the risk profiling of the client. So it was not checking whether the product is suitable to the client or not. Next was it did not do any suitability assessment after risk profiling. It had various websites, one marketing for one for marketing, one for others, and it disclosed data, but the data was incorrect or faulty or misleading. Then it was also providing execution services, which was not clearly segregated. The company was not acting with due diligence and care towards its clients. It was not acting in fiduciary capacity. It was just giving advice to clients and not checking whether it is suitable or not. Of course, the fees charged was reasonably high as per SEBI. It also did not maintain records which are required under regulations. The employees which work for this company did not have the requisite certifications which are required under SEBI regulations. And it was basically not following or complying with the role that an investment advisor needs to play when it comes to giving advice to the client. Is it too much of a thing to do? Do you think that the list is long and we have to do so many things? I'm sure you must be thinking this, but I will help you simplify the processes here and understand the compliances and SEBI point of view as well. Okay, so as I have briefed you on the non-compliances, I will tell you now how you can comply and not come under SEBI's eyes. So SEBI had issued a regulation known as KYC KRA regulations, and in those regulations SEBI has given a process on how you can do the KYC of the client. The process includes that you need to have an account opening form. So it's a normal form where you take data, personal data of the client, including the name, address, PAN number, as well as take the copies of address proof and identity proof for the client. You have to retain those copies. It can be scanned copies as of now, but the regulations require to retain physical copies. I've seen most of the RIs, they do retain the scanned copies, which even you can do in my view. And if at all SEBI comes for inspection, you can always give a printout to SEBI that you have complied with the KYC norms. Of course, you have to upload the KYC information on the KRS system. And now, recently SEBI issued guidelines and circular where you have to upload documents on the CKYC, that is a central KYC portal. This is applicable for all the investment advisors as you are registered as an intermediary with SEBI. This portal requires a maker and a checker person. So you need to have two people in your organization so that one can be a maker, one can be a checker. You will need a digital signature, a DSC, to upload the documents on the CKYC portal. And of course, it will be the responsibility of the intermediary, that is you as an investment advisor, to update the information if there are any changes in the KYC documents of the client. And of course, you need to retain the updated or revised documents. Next, we go to the risk profiling. In my experience, I have come across people who do not do risk profiling and they think that whatever product they offer or advice they offer is suitable to all kinds of investors. But SEBI needs you to do risk profiling before advising any product or any security to your clients. So, how do you do risk profiling? Do you have a tool or do you have software to do risk profiling? Most of you must be using Excel. All that is fine as long as the client fills all questions, answers all questions in the risk profiling questionnaire. But risk profiling doesn't end at just taking the risk profiling questionnaire. SEBI is expecting that you as an investment advisor, the person should also do the risk assessment of the client. Because the risk profiling questionnaire may or may not be foolproof. There may be questions which client thinks that he or she can do, but maybe his ability to absorb risk may not be as per the answers given in the questionnaire. So it will be the responsibility of the advisor to get involved in the risk assessment process along with the questionnaire. And when you do risk profiling, you should also take into account the assets and liabilities, income and expenditure pattern, and the overall ability of the client to bear risk and to bear losses. You should be able to assess whether he is willing to take a particular level of risk. So your risk profiling score or your risk profile of the client should be arrived at only after taking the questionnaire answers as well as your own assessment into consideration. Now you may ask that what if after assessing you feel that the risk profile is not as per derived by the questionnaire. This is a possibility and this can happen with a lot of your clients because they think that they can do something. They may answer questions based on their understanding. But after they talk to you, maybe you think that the profile is not as per the questionnaire. In such cases, you should discuss and communicate with the client. Tell him or her that this is your understanding and as per you, this is the risk profile of the client, and keep this in writing. So whenever your risk profiling process is completed, tell the client about his risk profile and include reasons if there are for deviation of risk profile from the questionnaire. So this is a mandatory compliance by SEBI that you should be communicating the risk profile to the client. Some of you who may have risk profile online and may have given access to the client to adjust his risk profile, I would recommend that you should log once the client does the risk profile, and if you think after he put the data into the platform that the risk profile is different, you should communicate it to the client. And one more requirement is that the risk profile should be updated periodically. Now this periodicity is subjective. There is no written rule or regulation which says that you should be updating the risk profile every 1 year or 3 months or 3 years. So this is up to you how you set your processes internally for risk profiling. In my view, whenever the client comes for review, you can do risk profiling again. It may or may not change, but at least you will have to see whether there is any change in his financial situation because of which the risk profile may change. And then accordingly communicate it to the client. So updating the risk profiling is mandatory. Period is not given, and it depends on how you assess the risk profile. Next. Next we go to suitability assessment. Okay, I'll take some questions at the end of the presentation. Suitability assessment. Now what is suitability assessment? It's basically that you assess whether a particular financial product is suitable to the client. Now in Capital VR's case, it was offering intraday advice which according to SEBI was not suitable to clients because a lot of clients didn't even understand what is the risk involved in intraday trading. So SEBI thought that Capital VR was responsible to assess the suitability of its advice to his clients, which Capital VR obviously didn't do. So its suitability is a basis to believe that an advice is suitable to the client's objectives and the risk absorbing capacity. You should have a documented process for selecting investments, based on which you can then assess whether that product or investment is suitable to the client or not. Now this is a requirement as per SEBI that you should be having a documented process for selecting investments. In the process, you can also mention that if the risk profile of the client is conservative, you will be advising him or her less risky or safer products. If you are into a business of only advising stocks or only advising mutual funds or only advising equity, what you can do is you can decide the asset allocation for which this client's risk profile, for which is suitable to client's risk profile. So for example, if the client's risk profile is conservative, you may give him or her large cap stocks, and also the asset allocation for him could be 30% in equity and rest in maybe debt. So this is just an example. You are the best person to judge, and accordingly you can decide the suitability of the client, of the advice for the client. Okay, this is a very important point in the investment advisors regulation, and that is disclosures. Why I say important is SEBI thinks that one way to tackle the conflict is through disclosures, and so disclosures are very important. They give the client a way to take a decision whether he or she should be going with your advice, or whether whatever you advise, he will have some basis whether its advice is biased or not. So there is no written format or document on how and when you should give disclosure. In my view, I advise all my clients that you can include a document which you can give to the client where all the required disclosures are mentioned, and this should be obviously given before the investment advice is given to the client, so that client can decide whether he or she should be going ahead with the advice or not. And Capital Via obviously didn't comply with this disclosure requirement. Even on its website, the disclosures which were made were not correct. So what all disclosures do you need to give to the client? One is about yourself, about the investment advisor. Now for companies, the disclosure requirement should be about the company and its management. For individuals and firms, it can be about yourself and your firm and the business of your firm. So the disclosure requirements about the investment advisor includes disclosures about the business. It can be like an introduction on what exactly you are doing. If you want to share your experience in the advisory business, you can do that so that client can get more confidence. If you have any disciplinary history against you, this you need to disclose to the client. Now, disciplinary history means any order or any notice which has been issued against you by any regulator. So this need not be like any client complaints against you for non-payment, non-receipt of refunds, or maybe some operational issues. That will not be disciplinary history. It will be only if you get any disciplinary action from any regulator. Then you need to also mention the terms and conditions on which you are going to offer the advisory services. You can have this in the form of an agreement between you and the client, where you can mention all the terms and conditions. Next is you also need to disclose about the affiliation, if at all you have, with other intermediaries. Now this can be in case of group companies, where one company can be a mutual fund house, or it can be a stockbroker, or it can be any manufacturer of a financial product. So basically, the client needs to know that if there is any conflict of interest when you are giving any advice to that client. Of course, you also need to mention correct information on your website. So, you make sure that whatever information is there on the website also matches with whatever information you give to the client. The next is receipt of compensation from associates. Now, this can be for companies, the associates can be subsidiaries, if at all they are into distribution or execution services. For individuals or firms, it can be your individuals, it can be your relatives if they are offering any execution services, and same with partnership firms. So basically, if you are receiving any compensation from your associate, you need to disclose the same to the client. Next is if you are recommending services of any other intermediary and you receive any compensation in form of a referral fee or in terms of fees, you need to disclose the same to the client. Suppose if you are recommending a stockbroker to the client and you are receiving some referral fees for that, you can mention the same to the client. But obviously, the client should not be under any obligation to take services from the stockbroker which you have recommended. Same applies to a mutual fund distributor. If you have tied up with some distributor and you're getting some compensation, you need to disclose to the client. But please make sure that it is not like a passback of commissions because it will not allow that. It can be like a referral fee or some percentage which you may get from the intermediary. And of course, the other intermediary is insurance agents with whom you can have tie-ups. So you need to disclose the same to the client, and obviously if you're getting compensation, you need to mention that you receive compensation. If you can mention percentage, it will be one step more towards compliance. Okay. Next is disclosures about any conflict of interest. So conflict of interest may arise if you have any association with issuer of products or securities. This disclosure is important because that may lead to compromise on independence of your advice. Now, examples of association with issuer of products can be that if you are in a same group company as AMC, where one company is a mutual fund house and has its own mutual fund products, and at the same time you also advise or recommend the same mutual funds to your clients. So you may not do it for receipt of any fees, or maybe there may be no bias in recommending that mutual fund to the client. But SEBI wants you to disclose this relation to the client so that the client knows that if at all there could be any conflict of interest, he may or may not agree to your advice, may ask you to change the advice. But you have complied when you disclose that you have some connection with any associate in maybe your group company, or maybe you have another LLC which can be involved in issuing financial products. Even if you are going to recommend a PMS to a client and that PMS company is your associate, you need to disclose the same to the client. Next is disclosure about holding position. This is again a mandatory disclosure which you need to give to your clients. Now, what is this holding position? So you need to basically disclose whether you hold the same stock or funds or the same investment product which you have advised to your client. This will be specifically to the names of the stocks or the mutual funds. For example, if a company or a firm invests its surplus funds in, say, parks its surplus funds into some liquid mutual fund, and you may also advise the same mutual fund to your client to park his or her money. At that very time, you also need to disclose the holding position in that liquid fund. Now, you may not disclose the units or the percentage of holding, but you need to still mention that you also hold so and so liquid fund. This you can mention at the time when you give investment advice. It's best that if you have a written document where you give investment advice, you can mention that like a note at the bottom. Or if you want, you can also give a blanket disclosure that you hold or you invest in this stock or this mutual fund. So this can be mentioned if you have financial planning services. This can be mentioned in your financial plan itself. Okay, then this is again one of the mandatory requirements that you need to disclose features of products, their track record, and warnings and disclaimers. You basically need to draw clients' attention to the warnings and disclaimers in the advertisement document which the issuer of product may issue. For mutual funds, it can be either in KIM or SID. For stocks, it can be either on the company's website or company presentation or annual reports. So you need to give adequate disclosure to the client about the material facts, that is the key features of the product. Now Capital VIA in its case did not give any disclosure to the client that the intraday trading or intraday product can be risky. So the clients were not aware whether that product can be suitable to them or not. And obviously because it was giving a short guarantee return, the client got attracted to the product. And SEBI obviously doesn't want that. So this disclosure should be given, especially in case of risky products like derivatives, which are very difficult to understand. So a layman will not understand what are the features of that product. And of course, you also need to give performance track record of that security. You can give, say, 1 year, 3 year, 5 year track record of whatever advice you have given to that client. Now this disclosure can be either or either in writing. What I would recommend is that you include a section in your investment advice document or a financial plan where maybe like a sheet where you can include the key features of the product and the performance track record. So you can say that, if you invest in equity, you are exposed to this risk and it's volatile. Same with debt products. And if at all you are also advising on, say, insurance or real estate or any other financial product, you need to mention the features. So, SEBI doesn't want investment advisors to conceal any material information which may mislead the client. And also, your sole objective should not be just to increase the revenue. If that is the case, it is definitely going to be dealt very sternly by SEBI. You need to follow this in spirit and disclose to the client all that information which you think that will help the client to make an informed decision. So with this, we complete with the disclosure requirements. And we go on to the next requirement, that is segregation of services. For individuals and partnership firms, you cannot provide execution services to your clients. Now, there is a gray area or debatable topic which says that if you are providing or facilitating direct plan transactions, direct plans of mutual funds, transactions in direct plans of mutual funds, you are allowed. I too believe this because simple reason is there is no conflict of interest if you are providing transactions in direct plans of mutual funds or if you have tied up with Zerodha and you're not getting any brokerages, you are, in my view, allowed to give such facilities to the client. Obviously, you will not do transactions on behalf of the client, but you are just giving a facility to that client. In such cases, segregation of services will not come into picture because this will be only seen as self-facilitation. But obviously, if you are a company and you are a company or LLC and you are providing other services, maybe like research services or maybe like execution services, you need to segregate those services. The services have to be totally different from investment advisory services. And how can you segregate? One is, if you have different employees for both the departments or for all the departments. So, investment advisors or representative of investment advisors should not be acting as research analysts or be involved in execution services. They should be only doing investment advisory services. So you should have different employees for different departments. For a body corporate, you can have a Chinese wall where you can segregate the departments and name them accordingly. And obviously, clients should not be under any obligation to use the services which are offered by the company, the other execution services. And of course, the fees, if at all you receive for other services you provide or execution services which you provide, they should be directly paid to that department. Now, this can be the one way to do it is if you have different bank accounts to receive advisory fees as well as commissions. So in that way, you can segregate the services. Next, we go on to fiduciary duty, which Capital Via failed to follow. It did not act in the interest of the clients, but obviously the sole objective seemed to be just getting fees from the client and increasing the revenue. So SEBI, if you see the third chapter of investment advisors regulation, the first point there is that you need to act in fiduciary capacity and you have a fiduciary duty towards your client. So it will be your responsibility to check whether that advice is suitable to the client or not. You need to own the responsibility of your advice. SEBI doesn't want that you just place blanket disclosures or blanket disclaimers for clients to read and think that it's the client's responsibility and you will not be incurring any losses or will not be liable if the client incurs losses. Now, this doesn't mean that SEBI will hold you responsible for client losses. SEBI is well aware that every advice cannot be financially rewarding to the client. There could be losses, especially in equity markets. Markets can be volatile. You may have your own basis to give advice to the client, which may or may not be profitable. But your responsibility will be to have proper basis to know that that advice is suitable to the client. So, placing blanket disclaimers for every client's attention does not meet the standards raised by SEBI regulation. And this is very well given in the code of conduct for investment advisors. If you refer to the code of conduct, code of conduct number 2, which says that the investment advisor shall act with due diligence and care and in the best interest of the client. And it should ensure that the advice is through proper, thorough analysis. And of course, you need to take various alternatives, take into consideration various alternatives, various available alternatives for advising. Also, the basis of your advice will be whatever information you get from the client. If at all you think that client has not disclosed all the information to you, your responsibility will be to take into consideration whatever information the client has given to you, and your advice will be based on that information. So next we come to maintenance of records which are required under the regulations. So here, not all records are required to be signed. You can maintain either physical copies or electronically. First is doing the risk profiling of the client. You need to maintain the risk profiling questionnaire for each and every client and how you have arrived at risk profile of the client. So the risk assessment document you need to maintain. This I'm referring to in case if you arrive at a risk profile which is not aligned with the risk profiling questionnaire profile. Next, you need to keep records of how you have done suitability assessment of that advice. If you have an internal process in place, which you obviously need to have, it should be your suitability assessment should be based on that process. And accordingly, you should be letting the client also know on how you have assessed suitability of the advice. Now, this suitability, like I said before, is not based on a particular security, but maybe an investment product as a whole. You need to keep copies of agreements if you have with your clients. Now, currently, this is not a mandatory requirement. And if you have agreements with your clients, you have to keep. If you don't have, SEBI is okay with it. But in my view, it's best to have agreements with your clients because this agreement can be like one whole document where you can mention everything about you, the terms and conditions, the fees which you will be charging, the tenure of your service, whatever services you're going to provide in that agreement, along with the disclosures which are required to be given to the client. So that document can be like a one whole document where the client knows everything about you and the services. So again, this is not a mandatory requirement, but if you see the first consultation paper which SEBI had issued, it had also given some guidelines on how and what should be included in the agreement with the client, which I'll be taking on in my other slides. Next is rationale for arriving at investment advice. Now this document, we want it to be signed and dated. So what is this document? How are you going to keep records of this document? This document is basically the reasons why you have advised a particular security to the client. You will need to mention this document. In this document, you need to mention the reasons on why that particular security has been advised to the client, on what basis is this advised, and that document has to be signed by you, and you need to put a date on which you have given the investment advice to the client. This rationale, if you are maintaining an electronic copy, then you need to digitally sign the copy. Next is register, which contains information on the client. Now this register can be either like your CRM where you have all the information about your client, or it can be maintained in an Excel sheet, and the columns could be the name of the client, the date of the advice, the date on which you have given the advice, the nature of advice, on which products you have given advice, and of course the fees which was charged for the advice. You can maintain an Excel sheet like an MIS wherein all this data is kept as records. And last but not least, of course, the KYC records of the client which you need to maintain. This can be scanned copies, but you need to maintain the address proof and the identity proof of the client. Okay, this is a very common question which I receive on what is reasonable fees, what is the limit till which we can charge fees, how we can charge fees, quantum of fees. So this is where we are. So SEBI has not given any view or any guideline as to the number or the percentage of fees which you can charge. But if you again refer to the code of conduct number 6, which says that fair and reasonable charges. So investment advisors may charge fees which are subject to any ceiling if specified by the board. So that is if any, but it is a responsibility of the investment advisor that it should ensure that the fees charged is fair and reasonable, which was not the case in case of Capital VR. It was charging reasonably high fees to the client. So SEBI has given the responsibility on the investment advisor to judge whether the fees is reasonable or not. You may argue that clients agreed to pay such high fees or such fees which you discuss with the client. But if there is any problem, SEBI is going to judge whether that fee was suitable or was reasonable for the advice or for the services which you gave to the client. So best, which I usually suggest, is you can keep a fee matrix wherein you can just give a range on the various products which you offer to the client and what fees you'll be charging to the client. And as far as possible, be consistent on your fees which are charged to the client. It can be across products, and you can also keep in mind the scope of your investment advice. So you can charge flat fee, which is a fixed fee charged to the client. Your fees can be based on the assets under advice or the assets under management. It can be like a percentage-based fee. And some advisors also charge performance-based fees, which in my view, an investment advisor cannot charge performance-based fees for the simple reason that the role of the investment advisor is just to advise and not to manage the money of the client. But SEBI has not given any view on whether it can or cannot charge performance-based fees, and it's up to the investment advisor and the client to mutually decide the fees for the services. So with these slides, I come to the end of the non-compliance part, which Capital VR did, and the various areas where Capital VR non-complied with. And this is a summary of what SEBI thinks is the role of investment advisor. So the role of an investment advisor is first to render advice in good faith. Obviously, it has to be in the interest of the client. It should be suitable to client risk profile. So if you want to assess the suitability, you have to do the risk profiling of the client before assessing the suitability. And it is a responsibility of investment advisor that advice is given only after it has collected all the necessary information and done a detailed analysis of the financial situation of the client. So, more importantly, you need to have continuous channel of communication with your client to understand what the client needs. And the advice can be after a detailed analysis, keeping in mind the overall financial interest and the financial situation of the client. And this was SEBI's view on the capital via non-compliance. So, the basis of the complaint was whether or not that level of risk was suitable to the client. The client must have given some information and SEBI thought that the level of risk the product which was issued to the client was not suitable to the client. It was a high risk product. In some cases, Capital Via also told SEBI that they were not aware of the requirements of II regulation. This was particularly to do with KYC requirements. SEBI thinks that ignorance of law is not an excuse. If you are registered under an investment advisor, you need to be aware of what is applicable to you and what are the requirements which are expected to be done from you. In Capital Via's case, the most serious violation was of non-disclosure of information to the client, and they did not do any proper risk evaluation of the client. So they did not have any proper risk evaluation process. SEBI also holds senior management responsible. So in your case, if you have a company, even the senior management should be involved in setting up processes and knowing that its representatives are following that process. And the last one was that Capital Via did not comply with the conditions of the certificate. Now, you would think that is there anything left to comply with when we say that conditions of the certificate? If you go back to the time when you were issued a certificate of registration from SEBI, you must have also been issued a letter along with it. So I would request you all to go through that letter which was issued by SEBI, because the conditions on which your certificate is valid was mentioned in that letter. Of course, the same conditions are also mentioned in the II regulations as well. And I will quickly go through them. So first condition is that if you want your certificate to be in place, you need to abide by the regulations which apply to you, including the intermediaries regulation, including the KYC KRA regulations, as well as you should abide by the code of conduct which is mentioned in the schedule of investment advisors regulation. If at all there is any material change in the information which you may have given at the time of application for registration, you need to inform SEBI about that change. This also includes that if at all during the application you must have told SEBI that you have only one representative or one employee which will be acting as an investment advisor. And during this course, you may have employed more people. Best is to inform SEBI that you have more people who will be giving advice on the behalf of the company. In case of partnership firms or other firms, if there are any changes in the partners, best is to inform SEBI about it. It can be in form of a simple letter, and you can give it to the regional office which is near you or to the head office of SEBI. The other last condition is that you need to use the words investment advisor in your name, or if you have separate department, the separate department should be named investment advisor. In case Okay, I'm sorry there was some issue with my internet connection. I will again go through the slide on SEBI's views. Okay, so as per SEBI, the basis of complaint would be only whether or not that level of risk was unsuitable to a particular client based on information given to the advisor or not. So it will not be if at all the client incurs any loss because of the advice given to the client, but it will be whether your assessment of suitability of the product has gone wrong or not. So you should not be advising any product which is unsuitable to the client, which is of high level risk, but the profiling of the client is conservative. So it will be the responsibility of the advisor to assess the risk profile and the suitability of that advice. In Capital VR's case law, Capital VR said that they were not aware about some requirements of the regulation, including the KYC norms, and SEBI said that ignorance of law is not an excuse. You should be aware of what is applicable to you and should be complying with them. In Capital VR's case law, SEBI said that the most serious violation is of non-disclosure to the client, improper risk valuation and dissemination processes. So the Capital VR did not disclose the required information to the client, obviously did not do any risk profiling of the client, which was again a non-compliance, and SEBI said it was a very serious non-compliance. In case of companies, SEBI will hold senior management also responsible if there is any non-compliance. So it will be the responsibility of the senior management to check whether the processes set by the company are followed by the representatives or not. And the last but not the least, compliance with conditions of certificate. Now you must be thinking, what is this? After all these requirements, is there anything pending? I will request you to go back to the time when you were issued a registration certificate by SEBI. Along with the certificate, you must have also been issued a letter by SEBI where the conditions of the certificate were mentioned. The same conditions are also mentioned in the regulation. So these are the conditions on which your certificate will be valid at all times if you abide by them. First condition is that you should always comply with the regulations which are applicable to you, and this also includes code of conduct, which is again a guiding principle which you need to follow. The other one is any change, material change, which has happened after the submission of application, that has to be informed to SEBI. So at the time of application, you must have told SEBI about your business, about the employees, about who will be your representatives. And after that, for example, you add more employees into your department, in your investment advisor department. Best is to inform SEBI about it. If there is any change of address, you need to inform to SEBI. If there is, for example, in case of companies, suppose the company has converted itself into a LLC or a public company, you need to take prior approval of SEBI. So you need to always keep SEBI under loop whenever there is a material change And the last condition is use of words investment advisors in the name or in the department. So in case of companies and LLPs, if you have a separate department for investment advisors, you can name that department as investment advisors department. And in your email signature, the emails which go from the investment advisors department to the client, you can include the word investment advisory department in the email signature. For individuals, firm, you can include the word investment advisors in your email signature. So basically this is for the client to know that an email has been received by the investment advisors department. So with this, I complete the compliance requirements of SEBI under investment advisors regulation. And now we again go back to the same slide on the typical RI process. And now I think you will be able to guess or judge whether this process is compliant or is perfect under SEBI regulations. Okay, so we are here on the screen where this is a typical RI process which we discussed earlier. And now you must be able to judge on whether this was the perfect process or not. First, when a prospect inquires about your service, he or she must have gone through your website. You need to update your website, the information on the website, which in case of Capital Via was not updated, also the information was incorrect. So make sure that the website information is correct. Next, when the client agrees to take your services, you need to give him or her the terms and conditions on which the services are offered by you. This can be, like I said, in the form of an agreement. And of course, you need to give the disclosure document to the client mentioning the various disclosures. The next is when you collect the financial information, you also collect the KYC documents of the client. And we assess the risk profiling and suitability of your advice. So this is to be given. This is to be done. The risk profiling has to be done before the advice is given. And when you decide on any advice, you need to also be sure that it is suitable to the client. After the advice is arrived at, you will obviously discuss with the client. So when the discussions happen via email, you have to mention the words investment advisor in all the communication. If you are giving an email of the investment advice, mention the words investment advisor. Once the advice is given, you again need to mention the disclosures. This is basically, you need to disclose the holding position. And of course, you need to give the rationale on the reasons on why you have given the advice to the client. What is the basis of arriving at that advice? So once the delivery of advice is given, you have to update the client register the register which is required to be maintained, mandatory requirements by SEBI, where you need to mention the products on which you give advice as well as the fees which you charge to the client. So now, in my view, this is a compliant RI practice. This is a compliant process which has covered the various requirements under I regulation. Okay. So at the time when the client comes for renewal, make sure that you have updated the risk profile of the client. Also, make sure that the KYC documents are updated. You should go to the client and ask if the KYC documents which he or she has provided, whether they are same or if there is any change. In between, there could be a change in the address of the client, which the client may have forgotten to inform you. So best is that you have in your processes that whenever the client comes for renewal, the same process is followed as it was followed when the client came first time. So this was the process which you should follow in order to comply with the regulation. Now I'll take you to other slide for knowing what can be the features of the agreement. So this is based on the first consultation paper which SEBI had proposed for changes in the investment advisors regulation. In that, SEBI had clearly stated that there could be a document known as rights and obligations document, which gave a brief guidelines on what could be the contents of this document. So by this, we could see that SEBI also intended that there should be some document which is given to the client in form of rights and obligations so that the client knows the features, scope, the tenure, the fees of the services. So what is the scope of service? So it's basically the services which you can provide under the investment advisors regulation, the services which are permitted under the investment advisors regulation. If you are doing any other service which is not permitted under I, you are not allowed to offer those services to the client. And it can be, suppose if you are managing clients' money and not only advising, then that is not allowed. Managing clients' money comes under PMS regulations. They are not allowed under investment advisors regulation. The next is type of instruments for which advice is given. This can be your stocks, mutual funds, or the securities, or the financial products. You should mention the tenure of your service. This can be for maybe 1 year, or if you have ongoing service, you can mention it's an ongoing service. Subject to maybe renewal. You should also mention the fees payable for your advice and the manner in which the fees is payable. I've come across some investment advisors where they charge quarterly fees, which you can write in your rights and obligations document. Then, if there is any performance-based fees, you should also disclose the same to the client. Now, this is important. You also need to disclose the risk involved in the investment advice which is given to the clients. This is basically referring to the products which you have advised and whether is there any risk involved, especially for risky products. Then you need to mention the rights and obligations, the liabilities which may have for investment advisory services, the disciplinary history, and statement of grievances or disputes. So this last point I would like to elaborate more. In case of companies and LLPs, since you have departments, you may have escalations through which the client can resort to in case the dispute or the query is not solved at the first level. So I would advise that you have some process on how the grievance is solved. It can be like first the client can get in touch with the investment advisor, the representative he is communicating with, or the advisor who is handling the client's case. If the grievance is not solved, it is escalated to, say, the senior management or the manager of that department. Then comes the CEO if you have, or the last resort is the board. So you need to mention this process to the client. Also give details about the compliance officer if you have for your company or your firm. You can mention the name, the email ID and the contact number of the compliance officer. And I hope that you all must be aware that there is a scores platform by SEBI. Now this scores platform, investors can go and complain against the registered intermediaries, like how in case of Capital Ria's case, a client must have complained to SEBI. To get access to this scores platform, you need to submit a form to SEBI, and SEBI will give you the login ID and the password through which you can know if there are any complaints against you. So you need to access the platform regularly and see if there are any complaints. So if you have not registered on the scores, you can go and do it now. It's of course free of cost, but do it. So this rights and obligation document, you can also mention that past performance of investment advice does not indicate its future performance, as well as you have to make the clients aware that investment in securities market are subject to market risk, and there is no assurance or guarantee that can be achieved from the investment advice. SEBI in that consultation paper also said that investment advisor has to obtain an acknowledgement from the client that he or she has read and understood the terms and conditions of the advisory service. The next section is compliance audit, which is mandatory under IA regulations. So the compliance audit, whatever we have discussed up till now, that forms the part of the annual compliance audit. And you should be ready with the records and the processes which have been discussed till now. This annual compliance audit is mandatory for all the investment advisors which are registered in the SEBI. There is no period on when can this audit be done, but if you go through the spirit and the consultation paper, SEBI had mentioned that it can be done after the end of the financial year, which obviously did not become a regulation, but we can follow that for annual compliance audit. So since the financial year has completed, you can engage or hire any practicing company secretary like me or any practicing chartered accountant to do the compliance audit of the records you have maintained. So we can quickly go to the checklist for the annual compliance audit. This checklist I have divided into internal processes which the company needs to follow, as well as the checklist which is the client processes. First is the qualification and certification of the employees. Requirements for qualification and certification should be complied. All the employees and representatives of the investment advisory department should fulfill the qualification and certification requirements at all times. Now, this certification requirements, if you have done level 1 and 2, they must be renewed before it is due for renewal. That is every 3 years. So before the due date, you should renew the certificate. And for qualification, you can the employee should have professional qualification certificates or the postgraduate diploma or degree if they have. They should present this. You should keep the records of those certificates. If you don't have the certificates, you best to keep the records now. Next is statement of net worth. So this, you all know that for individual the requirement for net worth is 1 lakh. Same for partnership firms. For LLPs and companies, the net worth is 25 lakhs. You need to have net worth at all times. So if you for companies, you can present the balance sheet which shows the net worth. LLPs, same. For individuals, either you have bank account where you show net worth of 1 lakh, or you have any assets, you need to keep those records. Third is if you have any email communication or correspondence with SEBI, that is in case of any changes. If you have informed SEBI, you need to keep records. For this, Form A will be the basis to check if there are any changes, and accordingly the auditor will ask you whether you have informed SEBI or not. Fourth is, of course, the written process for selecting investments. Then you need to have written process for risk profiling of the client, and a process for redressal of grievance, which we discussed last. So if you don't have course login ID, please go and do it immediately, and then mention the name, number of the compliance officer, as well as inform the client that you register on course. So this were the processes for internal compliance. Now we go to the compliance list to the clients. First is obviously client's correspondence. Keep a copy of the letters or emails or documents like financial plans which are sent to the client. And obviously you need to mention the word investment advisor in all correspondence with your clients. So the external auditor will need these correspondence to check whether you have mentioned investment advisors in the correspondence. Next you need to give the risk profiling questionnaire of all the clients. The process where you have assessed risk, or if you have any other tool, you need to maintain that. Next is communication of risk profile. How you have communicated that document or that thing you need to keep. If you have communicated orally, better to communicate in writing as well. So if you have an email communication, keep records of that email. Then this is a disclosure document, the disclosures which we discussed. It's best to have all the disclosures in one place so that you and the client are aware of whatever has been disclosed. And it is easy for the external auditor to check the disclosures requirement has been met or not. Then you need to keep the KYC documents of the client, the KYC form, the introduction form, the identity proof and the address proof. You need to maintain the document where you have assessed the suitability of your advice. This can form a part of the document where you give investment advice, or if you have mentioned anything in the email, you need to mention, you need to keep records of that suitability assessment document. Then if you have client agreements which are signed by the client and you, although it's not a mandatory requirement, but it's better to have the agreement records of the agreement. Now you also need to keep document for investment advice provided. If you have already provided an investment advice, suppose if you have any phone communication with the client where you have given advice to the client, I would advise that you also mention the same in writing about the discussions and the investment advice given to the client and maintain records. If you have financial plan which you give to the client or any other document which you give to the client, you need to maintain the records of investment advice. In case of investment advisors who have platforms on which investment advice is given, keep records of those communications, keep logs of those communications with the client. Then you need to keep rationale for arriving at investment advice. This has to be signed and dated. If the document is kept electronically, you have to digitally sign it, but you need to give the rationale for all clients. And the last is register of clients, where you need to mention the name, date of advice, nature of advice, the products and securities on which advice is given, and the fees which is charged for the investment advice. Okay, next we go to the slide which has cost of compliance. Now this table is applicable to all those IAs who are in the initial years of their practice. Obviously, as the practice or business grows, you can start incurring costs to maintain the records. But initially, this is my understanding and whatever I have seen. And this is the presentation. So what are the areas because of which you can incur cost? One is the risk profiling tool which you need to have. Now this questionnaire, like I said, can be maintained in Excel sheet and given to the client. So if you obviously have Excel, your likely cost is 0. If you are not using CRM and you are using emails and Excel sheets to communicate with the client, even if your financial plan is in an Excel sheet, again the likely cost is 0. Now, partnership firms, companies and LLPs need to hire compliance officer. So, I'm sorry, not need to hire, but should keep a compliance officer. So SEBI has currently not given any eligibility criteria or any qualification requirements for compliance officer. For individuals, they themselves are the compliance officers who will be responsible for the compliance. For partnership firms, they can appoint, if they want to appoint, they can appoint a person or any of the partner can be the compliance officer. In case of companies and LLPs, again, some internal employee can be the compliance officer who will be responsible for compliance of I regulations. And so, if you already have an employee or any of a partner or director is a compliance officer, the likely cost again is zero. To maintain KYC docs, you need to incur some cost because to upload the KYC docs on the central KYC portal, you need to have digital signature for the maker and the checker, which may cost you maybe around 2,000 rupees a year. So this is a small cost which you need to incur, and of course if you have to print some documents. And the last but not the least, the annual audit, which you may have to incur cost and for the professional fees of hiring an independent auditor. So since we have covered the cost of compliance, I think we should also cover the cost of non-compliance. What could be the penalties which SEBI can levy on you in case of non-compliance? Now I again want to reiterate that if at all your advice does not generate profits for the client, that is not a basis of complaint for the client. But if you have not complied with the requirements of the regulation and then given the advice to the client, then that definitely becomes a basis for the complaint to the client, to SEBI. And if there is inspection by SEBI and SEBI doesn't get convinced on your representation, the penalties can be levied by SEBI, and the recent Finance Act gave more powers to SEBI. So penalties can be 1 lakh per day to up to rupees 1 crore for the registered investment advisors and research analysts. So the penalties definitely will not be less than 1 lakh. Also, SEBI may, like in Capital Via's case, ask you to stop your business for some period till you comply with all the requirements. So non-compliance can lead to closure of business, and your directors and your key management personnel will also be responsible for the non-compliance. So when SEBI issues orders or levies penalty, the SEBI will consider the amount of disappropriate gain or unfair advantage which you may have because of the non-compliance and because of the advice given to the client, the amount of loss which the investor must have incurred as a result of the default on your part, and SEBI will also consider how repetitive is the default on your part. So based on these factors, SEBI will decide what can be the quantum of penalty which can be levied on you in case of non-compliance. So why let SEBI come to you? Best is to comply with the regulations, because I believe that the cost of non-compliance is much higher than the cost of compliance. So I would always suggest you that you should follow the regulations in spirit and not try to conceal material information which can be misleading to the client, and obviously not have the sole objective of just generating revenues and not take client interest into consideration. So follow the regulation in spirit and you will always be compliant with the regulation. So I will also advise you to go through the code of conduct for investment advisors. because whatever we have discussed up till now, that summary could be the code of conduct for investment advisors. With this, I've finished my presentation and we can now take the questions. I will be sharing this recording with you along with the presentation for your records. Okay, someone has asked whether it is okay to download the KYC of the client from the KRA system. Yes, it is okay to download, but you still need to maintain for your records the identity proof and address proof of your client. You may not do the central KYC procedure, which may have been done by other intermediary, but it will be your responsibility to still keep the KYC documents of your client. Some companies may provide execution services for which they don't charge to the client. So, for companies, if they have separate department for execution, currently they are complied with the regulations. But in case of individuals and partnerships, if they are providing execution services and not charging fees for it, also not receiving any commissions for it, then in my view, they comply with the regulations, because simple reason is there is no conflict of interest. Okay, someone has asked whether to do central KYC, there are two people required. How can it be done for an individual RIA? So there still is a gray area. I don't know whether SEBI has thought about it. If what you can do is, if you have some other employee, if you have a sole proprietorship and have some employee, you can hire someone to be the maker and upload the KYC documents, and you could be the checker. Till there is no classification from SEBI, I would still advise you that at least you keep the KYC records of your clients. If there's someone who has asked whether fees and wealth management charges can be charged together. So from this question, what I understand is, whether you can charge fees for advice as well as charge fees for the ongoing management of the advice. So yes, some advisors are doing it. They are charging flat fee at the start of giving advice, and if the client agrees that he also wants that client to be on a retainer basis and not manage, but at least follow that whatever advice has been given has been executed as per the plan, and charge fees for the same, then yes, you can do it. But if you are charging fees for management, and by management I mean that if the client is giving you money and you are managing it like a portfolio manager, then it will not be allowed. If you have specific queries on KYC, please let me know. For KYC, again, you need to keep records of the client. And recently there was a circular issued for central KYC uploading, which every individual as well as companies who are registered under the I regulations. They are called intermediaries, and then they have to upload the KYC documents of the client. If the KYC documents have already been uploaded by any other intermediary, request your client to give you the 16-digit or 12-digit number, which you can keep for records, but still keep the KYC documents for your records. Okay, some participant has asked whether RIs can also have EUIN. So if you are an individual, you cannot be both I as well as mutual fund distributor, and obviously cannot have EUIN. But in case of companies, you can have, which have separate departments. In case of some participant has asked how to do KYC in case of foreign investors. So procedure is the same for Indian as well as foreign. You can have passport copy as address proof for foreign investors as well as identity proof. I hope you all also know that you cannot advise clients which are resident in US and Canada. That is because of the strict SEC rules. There is some limit given, which I can get back to you, but in case of foreign investors, if they are not Indian residents, then in that case, I'm not very sure about the KYC requirements, but still you can at least take their passports for your records, passport copies for your records. For KYC records, if you need to upload on the CKYC portal, and that is covered under the KYC KRA regulations, and if you are not doing it, then you're not complied with the KYC KRA regulations. So yes, you should start uploading the documents on the CKYC portal. If you are an individual investment advisor who had ARN before, as per the second consultation paper, SEBI said that you can still receive trail commissions, but you cannot solicit new business under ARN. So there is still some clarification which is expected from SEBI regarding this. But whatever has been said in the second consultation paper, my view is you can continue to receive trail commissions, but you cannot solicit new business under your ARN. Okay, someone has asked whether they can give advisory services to a broker. So this kind of arrangement, you mean to, what I understand is whether you can give the names of the funds or the stocks to the broker and the broker gives advice to you. In that case, you are not into investment advisory business because you are not even knowing the client and not assessing the risk profile and the suitability of that advice, and you are just giving research to the client. So that doesn't come under investment advisors regulation. Okay, I've got one more question on, can the spouse have an MF distribution license and the individual can be an investment advisor? As of now, that is allowed by SEBI, but if the third consultation paper comes into a regulation, that may not be allowed by SEBI. As long as currently you're disclosing that your spouse has the MF distribution license and you are recommending service of your spouse, and also disclosing if you are receiving any fees from your spouse, it should be allowed. I've got a question whether authorization of transaction on the behalf of the client can be done in case of direct equity. What I understand is that you will be initiating the transaction and the client will be approving it, and only then it will be going to the broker. If that is the case, it will be allowed as long as you are not receiving any fees for providing such services. And this is, I assumed you will be an individual investment advisor. Okay, I've got one more question. What if the client refuses to give KYC documents or risk profiling? The simple answer is you should not give investment advice to that client. Okay. One more question is it important that everyone who is working with individual RIA has to clear NISM level 1, level 2? First of all, individual RIA cannot appoint any other person in his proprietorship firm for investment advice. So since he cannot appoint anyone, definitely they do not have to do NISM level 1, level 2 exam. If the RI has appointed some person to just collect information on the BISPA from the client, or maybe just collect documents from the client and help in collating those information, then that person is not an investment advisor and hence do not require to do the NISM level 1, level 2 certification. One question is, for compliance, do we need to submit any certificate or need to maintain and follow? If you are referring to the annual compliance, which is mandatory by SEBI, yes, you need to follow that requirement and maintain the certificate which will be given by the external auditor. But as of now, you did not submit that certificate to SEBI. Okay, one more question is, it important to update correspondence address to SEBI? Yes, it's better that you inform SEBI about any change which may occur after the registration. Basis can be the application form. So if there are any change in the information which you have submitted to SEBI at the time of application, best is to inform SEBI about it. So, again, a question whether potential clients who are NRIs and residents of US, you should be very careful in dealing with them. Simple reason is SEC regulations do not allow to solicit or service US citizens or US based persons. I am not very sure, but the number is not more than 15. So if it is not more than 15, you can solicit, but I'm not very sure. I need to check and I'll get back to you. But SEC regulations are very strict, and unless and until you are registered with SEC, that is a US investment advisors regulation, you cannot solicit clients from US. I have got one more question. Is it important to fill entire risk management? I'm sorry, I'm not able to get the full form of RPM. If it refers to risk profiling questionnaire or risk profiling management software, then yes, it is important for the client to fill the entire risk management questionnaire or the risk profile questionnaire. If anyone wants to inquire fees about my professional services, you can separately write to me. Send me an email on my email ID, kruti@cskruti.com. I've got one question: whether can anyone register under both investment advisor and research analyst? So the good news is, under research analyst regulations, there is an exemption for all those people who are already registered as investment advisor. So if you are also providing research services to investors, you need not get registered under research analyst regulations, but you'll have to comply with the Chapter 3 of research analyst regulations. That simply means that you should not file an application form with SEBI and pay SEBI fees, but you need to comply with the various requirements of the research analyst regulations. You should be able to segregate between your activities as an investment advisor and as a research analyst. One question, is it important everyone who is working with individual RIA, and that has been referred to as sales and digital marketing department. So that is not a department under investment advisory regulations, and hence need not comply with the qualification certification requirements. I've got a question whether it is mandatory to have client agreement. No, it's not mandatory, but it's suggested. I am not sure whether it is mandatory to take Aadhaar number. Someone has asked, if we register as IA and we do not get any single client in a year, still do we need to do compliance, or still we need to have a compliance certificate? There are still some compliances which are not related to clients but are related to the internal processes, and if you have not got client, in my view, you should still need to have the compliance audit done. This question, if we are collecting online KYC docs, do we need to go through any scan process at the time of uploading by the client? So for KYC, you need to take address proof or identity proof. You can get scan copies of those proofs, and the scanned copies are to be uploaded on the CKYC portal. Next question is, how can we find circulars from SEBI? Best is to visit SEBI website or subscribe to SEBI newsletter and you get SEBI's email every day. At the end of the financial year, what information are mandatory to be submitted to SEBI? So registered investment advisors, I hope you know that there is a SI portal on which you can log in and see if there are any submissions which are required to be given to SEBI. Once you log in, you will get a work list of those submissions, and that is to be submitted to SEBI. Apart from that, currently you need not submit any other document to SEBI, and this also includes that you need not submit the compliance certificate, which is issued by an independent auditor. I've got a question, any compliance certificate different from net worth certificate? So what I understand your question is whether there is any certificate different from net worth. So net worth certificate just gives certification of the net worth, but the compliance certificate by an external auditor, be it a practicing CS like me or a practicing CA, that certificate will have observations on the various compliance which you have done under the SEBI I regulation. Next question is, investment advice provided oral, how to maintain records? Like I said, I suggest that even if investment advice is oral, write an email to to the client on the discussions which you had with the client, including if you have given any advice. For oral communication, SEBI has not issued any guidelines. And if you want to comply with oral recording also, then yes, you can record phone calls. Is RPM scoring mandatory to show on the website? So if you have a portal where you show the various information about the client, you can also show the risk profile of the client. You need not show the score, but after the score, whatever profile you've arrived at, you need to show that client either on the website or through an email. Again, I've received a question, can an investment advisor also work as a research analyst? If you are referring to companies, then no, because then segregation will be an issue. In case of individuals, if he is also providing research services, then he can act as a research analyst, but you will have to comply with Chapter 3 of Research Analyst Regulation. Whether can individual RIA hire telecaller and whether he or she should be NISM certified. So if the telecaller is just going to introduce clients and just give information about the services, then definitely he should not, he may or may not be NISM. It's not required for the telecaller to comply with NISM certification. In case of individual RIAs, only the RIA who is registered with SEBI can give advice, and only he or she should be compliant with the qualification and certification requirements. This is a question, what do you mean by representatives? So representatives are those people who on behalf of investment advisor provide investment advice. So those are employees or agents of investment advisor. In case of individual, he cannot have representatives who will be providing investment advice as he is responsible for providing investment advice. And same with partnership firms. If they have investment advisors, partners and investment advisors, they are responsible. In case of companies, investment advisor employee can be different from directors or shareholders, of course. So in that case, the employee becomes the representative of the investment advisor. And if the company has hired an outside consultant to provide investment advice to the client on the company, then outside consultant is the representative, and that representative needs to comply with the qualification and certification requirements. The question is, can you share details of the internal compliance as mentioned by you in case of no client is received? That will be the internal processes, the checklist which I had mentioned for internal processes. That is that if you are an individual, you should fulfill the qualification and certification requirements at all times. If you are a company, then obviously your employees should fulfill. You should maintain the capital adequacy at all times. If during that 1 year you have made any changes, then the communication to SEBI has to be complied with. Then you need to have the internal processes for selecting investment advice, internal process for risk profiling, internal process for suitability, and the process for redressal of grievance. Is PAN card mandatory for client KYC purpose? I think yes, it is. I've got last question. Kindly share the link to check the list of documents to submit at the end of the year. The link is siportal.sebi.gov.in, wherein you have to log in and see if you have any work list in your login portal. Do you have any further questions? Please let me know. I'll wait for 5 more minutes. Meanwhile, I will also request you to go through this slide where I have mentioned my services. I do help individuals, partnership firms, companies, and support them in compliance requirements. So my services are one-time setup service where I help the initial setup, which is required, setup of processes which is required under IR regulations. I can also come on board and help you with the ongoing compliance of regulations. And I'm also eligible to conduct the annual compliance audit which is required under IR regulations. These are my contact details, and you can get in touch with me for further inquiries. I have a question that in case of research analyst, there is a limit on the personal trading, that is, you cannot trade 30 days prior and 5 days after the publication of research report. And does it apply to eyes? So if you are only into investment advisory services, definitely it will not apply. But if you are also into research services and publication of research reports, then it will apply to you. I've got a question. How much time is required for KRA agencies to give the user ID and password? I'm sorry, I'm not aware of that, but it takes time for the KRA agencies to respond to you. Do we need to hold in for any specific period under the regulations? I guess you're referring to the holding positions. So again, in case of I, the only requirement is that you cannot do trading which is exactly opposite or contrary to the advice which is given to the client. What if the client denies to fulfill the RPM? You should insist, and if he still doesn't do, then your investment advice will not be based on the information which client has given. So please insist the client to fill the entire questionnaire. Is salesperson also termed as representative? In case of individuals, no, because for individuals, the individual himself is a representative. And salesperson, I believe, and should be only doing sales and not doing investment advice. What happens if client doesn't give KYC or do risk profiling? You should not be giving investment advice to that client. The refund process is your internal business call, which you and your client have to decide. In my view, you can refund the money if you are not providing any services to the client. What is important questions which need to be filled in RPM? So, basically, your risk profiling questionnaire should help you to assess the risk capacity for client's capacity for absorbing risk. You should be able to identify whether the client is willing or able to accept the risk or loss of capital, whether he is willing or unwilling to able to accept the risk of loss of capital. And of course, your question should be also able to understand what all are his financial needs, his income expenses, asset liabilities, his risk tolerance capacity. I'll be sharing the recording with you as well as the presentation. I'm not able to understand the question on the NISM level 1, level 2, pursuing NISM level 1, level 2, but not offering I. Can we fill RPM on behalf of the client? Definitely no. I hope you all understand that the risk profile is the requirement which has to be initially done before giving the investment advice. And Capital Via did not do risk profiling at all, and hence it did not comply with the requirements. The risk profiling assessment will help you to know or judge whether what kind of advice can you give to their client, and also be able to judge the suitability of your advice, which asset classes can you give to the client, what are the securities particularly which you can give to the client. If the client's risk profile is conservative, you should not be definitely giving him or her any risky products. So risk assessment does the job of assessing whether what kind of advice can you give to the client. And that's the reason why risk profiling is mandatory. You should insist the client to complete the questionnaire because it will be in his good so that you can give a proper advice to the client. Okay, if we have cleared NISM 10A, 10B exam but do not offer I, can we in public mention ourselves as, you can mention yourself as NISM certified, but you will not be able to mention as an investment advisor unless you get registered with SEBI. Does anyone have further questions? Someone has asked whether he has a client and the client is a sub-broker. So you have to advise the client irrespective of whether he or she is another intermediary, because that client, you have to advise the client on his or her personal financial requirements. Your sub-broker can be your client, but you will be advising on his or her financial needs. Okay, I guess there are no more questions. I will end this session, and if you have further questions, you can email it to me at kruti@csv.com. Thank you all for attending this webinar, and if you have questions, do write to me. Thank you. Also would like request you to give some feedback.